Newzroom PM, thanks for staying on. In a bid to protect citizens from unethical legal practitioners, the Legal Practitioners Fidelity Fund has launched a nationwide awareness campaign with the latest community engagement held in Kariega in the Eastern Cape. The initiative aims to educate the public on how to report dishonest attorneys and claim compensation when money or property is stolen. Since 2018, 57 attorneys have been disbarred, some accused of stealing millions from clients, while more than 500 cases involving over 1.4 billion in misappropriated trust funds remain unprosecuted. Joining me now is Motlatsi, CEO of the Legal Practitioners Fidelity Fund. Dr. Molefe, good to have you. Thank you very much for your time. We are told by Glenys Breitenbach, Advocate Glenys Breitenbach, says 561 trust funds theft cases unprosecuted worth 1.4 billion. Says only 59 convictions in 7 years and just 25 resulted in jail time, demanding answers. Now the question is, do you consider these statistics as the LPFF a concern, right? Number two, do you think that these statistics are an indication of incapacity or unwillingness on your part, the LPC and the NPA?
Good morning, Thabo, to you and to your viewers. Firstly, I should point out that we do not believe that the statistics do justice to the work that we are doing, first and foremost. And secondly, do not do justice to the public itself in the context of the numbers involved that go on trial and the amounts of monies that are stolen. What one must understand is that there are certain processes in place that we use to try and get people to be disbarred. And we are not the institution responsible for disbarring people. It is the Legal Practice Council that is involved in that process. But even they are hamstrung by legislation on the one hand, because some of the processes that they use to get there are imposed by statute, which controls their very existence. And secondly, some are basically the result of direct problems that we have with the courts. In South Africa, you've got huge backlogs, and there is no practitioner who gets struck off except if it is done through by a court because we're officers of the court. That is one thing on the one hand. On the other, in terms of internal processes, it is very, very difficult to get a matter to be finalized as speedily as one would like to see, because as I said, there are processes. Included in them is the right to be heard. And when these proceedings are initiated, you'll get as much resistance as you can imagine when someone is actually unwilling to take accountability. So those are some of the issues that lead to these backlogs and poor statistics. But even more importantly as well is the fact that members of the public themselves do not go out of their way to notify either ourselves or the law societies as quickly as they discover these thefts. And you find that it is some time before we know about them, and it is only after the fact that we react to any scenario of theft of money. And finally, and even more importantly, the NPA itself has got its own issues with prosecutors not understanding in certain instances the concept of theft of trust monies themselves. So we have actually embarked on a process where all stakeholders try to get together to educate each other and to educate the public about what we need to do to curb this kind of scenario.
Now, if legal oversight bodies like yourselves and the LPC, further the NPA, which of course is the prosecuting body, are so hamstrung in this particular space to be able to hold crooked lawyers to account, what can mere communities do? How are you empowering them? How can they be more empowered than yourself to be able to tackle legal misconduct?
Well, firstly, Thabo, the reason why we are going to communities is to enhance people's knowledge about their rights in terms of the relationship between them and the practitioner. You know, in our country, the relationship has become infested with reversals. Attorneys are now seen as principals in the relationship, yet members of the public, the party who pays them, is in fact the principal, and they are the agents. People should know that. People should know that they have the right to demand from an attorney to see what is going on in their file, for instance. And secondly, and even more importantly, for protection to be there, they need to know if this particular individual with whom they are dealing possesses a valid Fidelity Fund certificate. And that certificate goes a long way in at least an assurance to an extent that this individual is in good standing. But over and above, even if it is so, we want them to actually also go out of their way to learn that there is nothing that stops them from telling us, even before they part with their money or property, whom they are actually engaging, and try to understand whether this individual is in fact in good standing. One of the things that is important is the fact that they ought also to know that a Fidelity Fund certificate is valid only for the year in which it is issued. And I don't think members of the public know that. So if you go to a practitioner and you ask him for a Fidelity Fund certificate and he shows you a 2023 certificate, you ought to avoid him at all costs. Yeah. You actually are not supposed to give him anything of your money or your property, or even let him prosecute your matter in any form or manner.
Yeah. Are you able to hold those people accountable, those who are brandying about expired certificates? What can you do yourself? Because the Democratic Alliance accounts this as inaction on your part in this particular matter, where it's almost as if you're shifting the blame to the community and saying, well, communities must themselves be vigilant and watch these things when you are entrusted with the responsibility of oversight.
No, that argument is flawed, Thabo. It is total balderdash. What we are doing is to go out of our way to ensure that people are empowered. We're not shifting responsibility. If you were to go on the website of the LPFF, for instance, part of the campaign is to name and shame these people so that the community should be aware of it and that they do not get away with it. As I said, the disciplinary process doesn't lie in the hands of the LPFF. It lies in the hands of the LPC. And we regularly generate reports because the app for the application for Fidelity Fund certificates is ran from the LPFF. We regularly generate reports and we actually pass them on to the LPC so that they should actually become, as soon as it's possible, aware of the people that don't hold Fidelity Fund certificates and take the necessary steps. But to say that we actually are passing the buck is, in my mind, totally flawed.
Do you think it's the correct approach, the one that you're taking? I suppose this awareness is always good, but should the priority not be more towards working with lawmakers, look at the Legal Practice Act, ensure that this condition of being hamstrung is dealt with to make it easier for the LPC to certainly bring the disciplinary steps?
It's as if you read my mind, Thabo. I woke up today around 2 a.m. and one of the things I was working on was an invitation to all stakeholders, both the regulators and the professional representative bodies, that we get together sometime in the first quarter of 2026 to look at all matters of mutual concern and, in fact, to look at the act itself. I'm of the view that certain elements of it are archaic. We need to make them more proactive than reactive. So in order for us to get that through with the legislature, we ought to come with one voice, sing from the same hymn book. So I cannot go there and say, this is how I see things, and the LPC says, no, well, we don't see things that way. So it's imperative that we, as professionals in the legal field, get together ourselves and drive the change in order to ensure that the legislature understands from where we come and where we want to go in terms of that kind of proactive reaction to dealing with problems in the legal profession.
Yeah. Now, in terms of your mandate, and especially when it comes to the poor, they are suffering at the hands of criminals posing as lawyers. What can be done immediately while we wait for that gathering in 2026?
Part of the problem is a very simple one. When you look at the act, as I say, it's archaic. But we are trying to find ways of working around it in order to settle claims as quickly as is possible, in order to ensure that people don't have a double jeopardy situation. Someone steals from you and there is an expectation that you go to an attorney. And when you go to an attorney, there's an expectation in the act that you should actually go and exhaust your remedies against that thief before you come to us. The issue is when someone is doing that, we're not serving the public. What is important, as I say, is to work around where it is possible to ensure that you settle these things as quickly as is possible. And as for these amendments to the Act that I think are necessary, these are things that we can work on as we also try to balance the scale between making sure that members of the public get action and redress as soon as is possible, as against waiting for years before they're actually put in the position in which they were before someone stole from them.
Yeah. How else are you mitigating risk, particularly when it comes to the practitioners themselves?
Well, there are many instances where we proactively watch what is going on out there. I mean, it's important for me, for instance, to be looking and trolling through social media, etc., to see, because generally what normally happens is that these people who misbehave tend to be particularly flashy as well. And these are things that are basically giving us cues about where we must deploy our resources. We're trying to make sure that our data analytics becomes better so that we can deploy our resources where we think it is best in terms of the numbers. You have to bear in mind that we don't have as much human resources as the number of practitioners out there. Then secondly, obviously, it is very, very important for us to continuously engage with the legal profession itself, to talk about the fact that it's not helpful for you to sit in the knowledge of someone who is a problem and you want to be collegial. You need to actually start making it clear to us that this is a problem, because this problem ultimately ends up having a situation where everybody is tarred with the same brush. So our engagements with them and their representatives are very, very, very engaging and high. But the important thing also with the public, and I really want to emphasize this, Thabo, it's not to shift responsibility. It's to work together in order to ensure that we get rid of elements that are miscreants within the legal profession.
See what you're saying, you peruse the socials and the fleshiness of the said individuals, high levels forensic stuff. I'm raising that because Outer says the forensic capability of the NPA is actually overstretched to be able to deal with all these cases, which is part of the problem. And I'm wondering if the Legal Practitioners Fidelity Fund could come in here and maybe prop up that forensic ability by getting proper independent forensic specialists to actually conduct that kind of work that you're alluding to, which you are doing ad hoc at this particular point.
Look, it's not even ad hoc, Thabo. We have a dedicated forensic unit within the LPFF, which looks at such things. You should know yourself as a broadcaster that more often than not, these people like to be seen. They like the limelight. And you will never believe the number of them that we have been able to identify through such issues. So in my mind, you need to have a team that knows what forensics is all about, but you also need to have a team that is flexible enough to be able to react as quickly as is possible. Dexterity is required because, firstly, you must remember, because of the nature of how the Act is structured, you end up coming in at the very end of the damage that has actually been occasioned. So the likelihood of situations where you find that even if we're talking millions that are stolen, it is difficult to recover them. We are trying to turn that around because we are now working strongly with other institutions. For instance, a few months ago, we went into a memorandum of understanding with the SIU, where in matters, for instance, of RAF or medical malpractice theft, they already are in possession of a proclamation from the president. So what's the point of me investigating? I don't think it's necessary. I simply refer those matters to them for them to actually investigate as against the cost to us. But what is important is they've got better teeth. They're able to track the money, even if it is offshore, and we're trying to recover that. Recently, as early as this week, before I left, I actually signed a new MOU with the FIC. The idea there is to share information around movements in trust accounts so that we may actually detect aberrations. If Thabo Mdluli attorneys normally transacts to the extent of, say, 100,000 in a month, and that's been a trend over the last 12 months, suddenly they receive 20 million, and in that 1 month only they've dispensed 19.8 million of that money, then that should tell us this is a problem, and we're trying to manage things by way of exception so that we should be able to focus our meager resources at catching the high-end criminals and actually root them out of the system.
The LPC has a suggestion, and I'm sure you won't say no to it. It's saying a major overhaul of legal oversight is needed and an urgent recapitalization of the Fidelity Fund, long overdue. What would you do with that extra capital if you do get it?
Look, part of the problem is I haven't read their proposal. And in my mind, it is true that we need an urgent review of the oversight scenario. But the recapitalization is a difficult issue in a society that is unequal. At this point, we are capitalized through trust interest and through trust accounts of practitioners. How people look at that is that seems to be their money, that is the legal profession. But the problem with that is that it is not. It is public funds. It is funds that must be directed purely at carrying out a huge responsibility of looking after the public. Where we can and where we should is also assist the legal profession in terms of sustainability of the LPC. But one must bear in mind is that the scale should always tip towards protecting the public, not tip towards making the LPC or the legal profession viable. It shouldn't be that way. We should understand very clearly. This is about the public. And if the LPC and ourselves move from that premise, then I don't think I've got a problem with that. But if we move from a different premise, then it's going to actually be a situation where we differ on certain issues. But I agree, we need to overhaul this.
We appreciate your time, sir. Thank you very much for coming on. That's the CEO of the Legal Practitioners Fidelity Fund, Motlatsi Molefe. Well,